Good evening, my dear friends, dosto. With this session, I wish to conclude section 73 and 74 of the GST Acts. I will be speaking more about dealing with the final order being passed under section 73(9) or section 74(9) after the end of the adjudicating process. So how to handle these orders? Of course, there are two methods. First, generally accepted method is going on appeal as provided in the GST Act itself. There are provisions for appeal, we can go. But also there are possibilities and ample possibilities of going to High Court under the writ jurisdiction to quash the order passed by the proper officer. So what are the grounds in which we can go to High Court or we can go to the appellate authority to get relief? The natural justice is one of the, as I said earlier, natural justice is one of the most frequent ground in which relief has been granted by constitutional courts. So the third limb of the natural justice is the right to have a speaking order, detailed order or a speaking order. Subsection 6 of section 75 itself says the proper officer has to pass an order with facts and the reasons behind the decisions. So what all this consists of, all this reasoned order or speaking order, we must understand. There are occasions, umpteen number of occasions, in which proper officer simply says, the assessee has not given any reply, therefore I confirm the proposals. assessee ने जवाब नहीं दिया, इसलिए मैंने उसको confirm करता हूँ. In some cases, in many cases, what happens? The proper officer states the representations, the replies given by the assessee is not acceptable and therefore the proposals are confirmed. First point I wanted to tell is that the proper officer who has issued the show cause notice, who has adjudicated the show cause notice, is the first level of fact finder and the law finder. He must find the facts and he must articulate the law, assert the law and ascertain the law. That is his responsibility. Section 74(9) says the proper officer has to determine the tax. The proper officer shall, after considering the representation, if any, made by the person chargeable with the tax, determine the amount of tax, interest and penalty due from such person and issue an order. It doesn't say confirm. Confirmation happens at appellate authority level. At the first level of fact finding, there is nothing called a confirmation. It is only determination. Reply from the representation from the assessee is optional. It is not mandatory. That's what it is said. After considering the representation, if any, but it is written shall determine the amount of tax and interest and penalty. So it is mandatory, he has to determine that. So first mistake, many places, many times I have seen is the proper officer simply confirms his earlier proposals. What actually he should have done to meet the requirements of the speaking order, what he must do is he has to first state what are the allegations placed, what are the contraventions he has alleged in the show cause notice, what are the facts that is brought up during the show cause notice, and then he must also discuss what are the evidences that has been placed by the proper officer in the show cause notice and what are the documents that he has relied. Then he must discuss what are the representations given by the Assessee, if he has given any document, evidences, what are those? And then out of this, what are those facts or evidences or documents accepted and what are not acceptable to the proper officer, and why it is not acceptable he has to say. He cannot say, I didn't like it, I am not satisfied, I reject it. He has to say why it is not rejected, why it is not accepted and why it is rejected. And then after making stating what were the allegations, what are the documents and evidences, comparing and analyzing the evidences and representations brought up by the assessee, he must then say, these are the findings of the facts. Finding means finding of facts. He has to say, these facts are found. That he has made so many lakhs of interstate supply of so and so good, which is taxable at the rate of 18%. The assessee has not paid the tax, or assessee was entitled to get only ITC of only 3 lakhs, but he has wrongly availed ITC of 6 lakhs. So he has to pay the 3 lakhs back or reverse the 3 lakhs. Or the assessee has availed or obtained refund wrongly to the tune of so much money. So these quantifications, the facts has to come out in the order itself. That is what the findings of the facts are. The quantification, the rate at which it should have been paid, when it should have been paid, what is the quantity actually paid, वो जब पूरा चीज़ों में आना चाहिए. क्या शॉर्ट पेमेंट किया, क्या रॉन्ग अवेलमेंट ऑफ आईटीसी किया, क्या एरनियस रिफंड ऑब्टेन किया, ये सब चीज़ों ऑर्डर में आना चाहिए. And then he has to come out a conclusion that assessee is liable for this much of tax and this much of penalty and this much of interest from so and so date at so and so rate. So, based upon the law and based upon the facts, he has to come to a conclusion. So, the conclusion has to be germane. It should come out of it. It should be born out of the findings. It cannot be, जब एक finding किया, कुछ और conclusion किया, कोई दोनों में कोई connection नहीं है. जो findings से अंदर से conclusion आना चाहिए. और ये दोनों आना चाहिए कहाँ से? Show cause notice से. It should be germane to the show cause notice. Show cause notice is the foundation of all the adjudications. So it should be born out of that. He cannot come. He is proposing 2.5 lakh rupees overpayment of or the wrong availment of ITC, and then he come out in the order 12 lakhs of wrong availment of ITC. That will not be correct. He has defended only for the 2.5 lakhs on the basis of the documents, on the grounds that the assessing officer has brought or shown it to the assessee or brought to the notice of the assessee, which he has got an opportunity to defend. And he could not defend, he could not repel. So he can go up to that level. But he cannot come on another ground, another amount, or on the same ground, a higher amount. It cannot happen. It cannot happen. They propose the action, the conclusion, everything has to be germane to the quantities mentioned in the show cause notice. The grounds taken in the show cause notice. And it should be the findings has to be germane to the evidences that he has shared with the assessee either during the show cause notice stage or if any fresh evidence has been adduced during the hearing, that also can be brought. But those evidence has to be taken in the presence of the accused or at the presence of the assessee only. So, entire findings, conclusion, decision has to be on the basis of initial allegations and after analyzing the evidence and the representation made by the assessee and germane to the, he cannot have new findings and new allegations and new grounds. It should be germane, it should be born out of, it should germinate from, it should originate from the show cause notice. ये बहुत important है. हमें कुछ बताया हम उसको कुछ डिफेंड करने की कोशिश किया, कुछ और पकड़ा गया, एडजुडिकेशन के टाइम में कुछ और पकड़ा गया, कुछ और दिखाई दिया उसको, अब उनको ऊपर ऑर्डर पास करते हैं जब पहले एक एलिगेशन था फॉर ए पर्टिकुलर अमाउंट और फाइनल ऑर्डर के अंदर में कुछ और ग्राउंड में और कुछ और अमाउंट का, हायर अमाउंट का लायबिलिटी फैशन किया। अगर ये स्पीकिंग ऑर्डर अगर ठीक से दिया, everything has been analyzed, what was the allegation, what are the documents, what are the statutory provisions, and what has been countered by the assessee, what is not accepted and why it is not accepted. If everything is properly given, then and when a finding is made and a conclusion is made accordingly, logically or well reasoned, then I have an option of going to High Court or going in appeal. Everything is there. If he has taken, appreciated, if he has taken this evidence, but he has rejected that evidence for wrong reason or right reason, सही तरीके से एनालाइज किया, गलत तरीके से एनालाइज किया, मैं अपील में जा सकता है। अगर ये पूरा बताया गया तो इन्होंने ये जो कंसिडर किया बट गलत रिजेक्ट किया, मैं अपील में जा सकता है। इन्होंने ये डॉक्यूमेंट को इस्तेमाल किया, मैं जो डॉक्यूमेंट दिया वो इन्होंने उसको रिजेक्ट किया, इस रीजन से रिजेक्ट किया जो इन्होंने बताया। If the assessing officer, the proper officer has rejected my document for whatever reason, then I can go in appeal and say he has rejected my evidence, he has rejected my document for a wrong reason, so I can go on appeal. If these things are not provided to me, how can I have an effective appeal? I cannot have an effective appeal itself. So, what does it constitute? It constitutes a lack of speaking order. And lack of speaking order is one of the major limb of denial of natural justice. So, natural justice has got three limbs: opportunity of being heard, nobody should judge on his own matter, and finally, issuing a speaking detailed order. So on that basis, I have to I have no other other than go to High Court. Because appeal court will not be able to say all those things, will not be able to give me relief on these grounds. On merit, they may be able to give. For that, the speaking order is required. So, suffice to say, there are two options even after the proper officer has passed an order under section 73 or 74, subsection 9. We can go in appeal, or we can go to High Court under writ jurisdiction. We have got these additional grounds, that lack of speaking order, absence of speaking order, denial of natural justice. Over and above, we have got all other grounds which are available to us earlier too. But then there may be a question, why we did not raise those issues during adjudication process. But it cannot be denied. If there is a denial of natural justice, opportunity of being heard at the issuance of show cause notice, जब show cause notice के टाइम में अगर आपको ये चीज नहीं दिया, आप बता भी सकता है, jurisdictional issues भी आप बता सकता है. No evidence, the matter is decided without any evidence, just because of that he proposed, and my reply has not been satisfactory, or I did not reply, or whatever reasons. He cannot determine it just like that. He has to determine as provided in section 74(9) or 73(9). He has to make a determination, not just a confirmation of proposals. So, other grounds like the procedure being violated to my prejudice, in which I have been injured, or my right has been violated because of the violation of the procedure. Apparent error of law or patent error of law, that he has interpreted the law, he has brought the law in a wrong manner. He has applied the law in a wrong manner, which is apparent. These grounds, which was earlier available, it is even now available. High Court is not a place to approach for determining the facts. Facts determination has to be done by the by the first level of fact finding authority, that is the officer who is adjudicating the show cause notice. Further, it can be done at the level of appellate authority. Then, when the appellate tribunals are coming, the tribunal also can deal with the fact finding, law finding both. So, all these places, the facts are being found. But writ court, when we go for a writ of certiorari, that is not a place where fact finding is entertained. It is left to the alternate remedy, it is left to the departmental remedy, the appellate remedy. But as long as we can make out a case for denial of natural justice, no evidence, procedural wrongs, patent error of law, or lack of jurisdiction, we can certainly make a good case in the High Court itself under the writ jurisdiction. So, I have now concluded. We have got two remedies. One is appellate remedy within the department, and further the appellate tribunal remedy, or we have got the remedy through the High Court under the writ jurisdiction. Thank you.